Everyone, this is Dave Stauss. I'm a data privacy partner at Hush Blackwell. I'd like to welcome you to our latest on-demand webinar. In this webinar, we will discuss the CCPA's draft regulations with respect to cybersecurity audits. If you've attended a prior webinar, you know we like to provide a roadmap for where our webinars are going. In this webinar, first we will take a look at who is covered by the cybersecurity audit requirements. Then we'll look at when the audits need to be performed, as well as the written certification requirements. And finally, we will look at the requirements themselves for the cybersecurity audits. Now, the latest round of rulemaking covers 5 topics. There are the topic we're going to cover today, the cybersecurity audits, as well as 4 other topics. We previously released webinars on automated decision-making technology, as well as revisions to the existing CCPA regulations, and we'll have one more webinar coming on the risk assessments. So keep in mind, though, that these are draft regulations. They are likely to change. They will change. So the goal of these webinars really is to provide a high-level summary of what's in the regulations for each topic, and we're trying to keep these webinars to 20 minutes or less. We're not trying to do a detailed analysis of every single nuance of the draft regulations, but rather just to provide you a good overview of what's happening. Okay, so let's start here with who is covered by the cybersecurity audit requirements. Okay, so not all businesses that are subject to the CCPA will have to perform a cybersecurity audit. Under the draft regulations, businesses whose processing of personal information presents, quote, a significant risk to consumers' security, end quote, must perform audits. The regulations go on to define what constitutes a significant risk to consumers' security. First, a business can meet that threshold if it meets the threshold in section 1798.140D1C in the prior calendar year. My guess is you do not have memorized what that section of the CCPA refers to. So section 140 is the CCPA's definition of business, and that section of the definition says that the CCPA applies to for-profit entities that derive 50% or more of their profit from selling or sharing personal information. So that basically covers data brokers. So again, if you trigger that section, then you're going to be performing cybersecurity audits. Second, if the business meets the annual gross revenue threshold requirement in the CCPA, and then it either processes the personal information of 250,000 or more consumers, or processes the sensitive personal information of 50,000 or more consumers, and that has to occur in the prior calendar year. So there's a few things we should tease out with that first, with those requirements, that is. First, the CCPA's revenue threshold is 25 million. That's what it says in the statute. Everyone knows that by now. But what you may not know is that earlier this year, the California legislature passed Assembly Bill 3286. And what that bill did was it amended the CCPA to say that the California Privacy Protection Agency must, starting January 1st, 2025, and then every odd number year thereafter, adjust that $25 million monetary threshold based on the Consumer Price Index. Now, the agency has to post that adjusted number on its website by January 15th. If you were really on the weeds on this, you know that the agency previously drafted a draft regulation in which it sought to increase the revenue threshold to approximately $28 million. But that was before Assembly Bill 3286 passed, so now the agency can just adjust it without rulemaking. Ultimately, though, I think, kind of reading where this is going here is we can expect, or would expect based on the previous draft regulation, we would expect the agency to increase that $25 million threshold. We'll wait and see what happens in January, but just be aware of that. Okay, the second thing I want to tease out is the CCPA does not exclude employees and B2B data from its definition of consumers. Remember, those exemptions expired. So when you're calculating these numbers here, these 250,000 and this 50,000, keep in mind that that's going to be all personal information. Okay, the third thing I want to tease out then is the CCPA's definition of personal information. As noted on the prior slide, you can trigger the cybersecurity audit requirement by crossing the revenue threshold and processing the personal information of 250,000 or more California residents. But keep in mind that personal information is defined broadly in the CCPA to include things like name, address, IP address, and email address. On this slide, we've given examples of personal information. There are more categories of personal information that are delineated in section 140. But again, things like names and addresses, online identifiers, IP addresses, right? And on the previous slide, you probably noted as well that this $250,000 consumer threshold is a very small percentage of the California population, something like 0.64% of the California population. So if you're talking about, these triggers at 250,000, it may not be as high as at first blush you would lead it to believe. You'd be led to believe, I should say. Second, keep in mind that the CCPA defines processing as any operation or set of operations that are performed on personal information or on sets of personal information. So, for example, storage would qualify as processing. Here are some examples of what's covered by the CCPA's definition of sensitive personal information. Again, a couple of slides ago, we showed that if you hit that 50,000, if you're processing the sensitive personal information of 50,000 California residents and you hit the monetary threshold, then you're performing cybersecurity audits. I should note also that the draft regulations, and we talked about this in one of our prior on-demand webinars, but the draft regulations are also seeking to add a new category of sensitive personal information, and that is the personal information of consumers that the business has actual knowledge are less than 16 years of age. Okay, so let's move on and let's talk about the timing and let's talk about the written certifications requirement. Okay. First, timing. The cybersecurity audit requirements would not be immediately effective. Rather, businesses would have 2 years to complete their first audit, and that time period runs from the effective date of the regulations, so the date that the regulations go into effect. And right now, the regulations would go into effect once approved by the Office of Administrative Law. Okay, so we would go through the comment period, we would finalize the regulations, the board would approve them, they would go to the Office of Administrative Law, and then the Office of Administrative Law would approve them, and that's the effective date. There was a court case that was involved. That court case is over, and it looks like where we've landed is the effective date is when the date that the Office of Administrative Law approves them. And then you have 2 years from then to do your cybersecurity audits, okay? But there's also an annual requirement. So after that 2 years goes up, then you've got an annual requirement to be conducting these cybersecurity audits, and there cannot be any gaps in the audits. Okay, I think this is a big piece of this puzzle, a huge piece, frankly. Not only do you need to do the cybersecurity audit, but you also need to file an annual certification with the agency saying that you did the audit. And that certification needs to be signed by a high-ranking member of the organization. Those who are familiar with the New York Division of Financial Services cybersecurity regulations will recognize where this requirement came from. But I'll suggest to you is requiring, and if this stays into the final regulations, and we'll see, but requiring businesses to submit to the agency certifications that these audits have been done, and then having, as you can see there, a member of the board, or if the board doesn't exist, a high-ranking executive having to sign and say that this happened, it certainly would increase the compliance pressure with respect to these audits. All right, let's talk about requirements. What do the audits actually need to do? Well, first, let's talk about who needs to perform the audit. The cybersecurity audit must be performed by an auditor. That makes sense. That auditor can be an internal or external individual to the company, but the person must be independent. The regulations go on to explain that, quote, the auditor must not participate in the business activities that the auditor may assess in the current or subsequent cybersecurity audits, including developing procedures, preparing the business's documents, or making the recommendations regarding implementing or maintaining the business's cybersecurity program, end quote. So it's got to be somebody, again, who's independent. It can't be your chief privacy officer who's writing the documents who then conducts the audits. If an internal auditor is used, that internal auditor must report directly to the board of directors or to the governing body. And again, if no such equivalent body exists, then the internal auditor would have to report directly to a high-ranking executive that does not have responsibility for the business's cybersecurity program. You can see again this issue of independence coming up in this draft regulations. Okay, let's turn to what the audit must include. At a high level, the draft regulations require the audit to go through each of the requirements of a cybersecurity audit. There's a subsequent 2 slides that will go through those. The audit must identify the gaps in the program. It must identify the status of gaps identified in prior audits, and then it must identify any corrective actions. The audit needs to be signed by the auditor, as well as a member of the board or a high-ranking executive. We talked about that on previous slides. And then the auditor must keep these audits for a minimum of 5 years. Okay, let's turn now to the scope of review. Overall, the audit must assess and document how the business's cybersecurity program protects personal information from unauthorized access, destruction, use, modification, or disclosure, and protects against unauthorized activity resulting in loss of availability of personal information. The audit must review documentation, including policies and procedures, and it must consider many, many components. This slide has the first 9 components. There's another slide that has 9 more components. We've had to divide them into 2 slides because there are so many. Obviously, there are many, many components here. The one that just catches my eye here is this inventory and management of personal information and information systems. So this is things like data inventory and data maps, right? So the audit has to review those. In order to review those have to be done, and that's an area in which I know a lot of companies try to spend time and energy trying to do those, and are very difficult to do. But there's also things like audit log management, authentication, the use of MFA and passwords, encryption, in transit and at rest, all of those types of things that the audit needs to be looking at. Moving on to this slide of additional requirements that the audit needs to be looking at. The things that catch my eye are things like retention schedules and disposal of personal information. So again, to be able to review those things, then the auditor needs to actually, the documents need to exist. The management of security incidents as well. My mind goes to things like preparing incident response plans, but also just how those are done within a company. Business continuity and disaster recovery plans. Again, like many businesses have these documents, but that's not the case for all of them. So this could be, for some companies, this could be an easy lift. For other companies, this could be a very difficult lift. Also on this list as well, the oversight of service providers catches my attention. So you're talking about things like, data processing agreements in place, but also vendor due diligence type issues. I should say, if the auditor, these are the 18 components that are identified in the draft regulations. If these things do not apply for whatever reason, then the auditor needs to be able to say why they don't apply to that business. Other requirements. The audit also needs to attach any breach notifications that were provided either to consumers or to regulatory authorities, and this would be redacted so it doesn't contain any types of personal information. Finally, businesses are not required to create duplicative audits, but if they complete an audit for another reason, i.e. to comply with another law, then the business must explain how that audit satisfies the CCPA's requirements, and if it does not, then the business must supplement that audit. That's it. That is our high-level overview of the draft regulations on cybersecurity audits. Thank you for listening. As I mentioned previously, we will have one more webinar in this series and that webinar will be on the draft risk assessment regulations. And we previously have done webinars on the draft regulations on automated decision-making technology, as well as updates to the existing CCPA regulations. Thanks for listening.